Hey guys, so today's topic will be the right to bail. This is in relation to Section 13, Article 3, still the Bill of Rights of our 1987 Constitution. So we always hear yung bailing out from jail, but do we really understand what is this certain right? So bail is the security given for the release of a person in custody of the law furnished by him or a bondsman conditioned upon his appearance before any court as may be required. Every person is bailable except for those charged with capital offenses when evidence is strong. It flows from the presumption of innocence in favor of the accused. It enables the accused to prepare his defense. It's mode short of confinement, which would, with reasonable certainty, ensure the attendance of the accused. So, who may invoke this right? A person under detention, even if no formal charges have yet been filed. This is under Rule 114 of the Rules of Court. So, why is bail awarded to the accused? It's first, again, as we said a while ago, it's to honor the presumption of innocence until the guilt of the accused is proven beyond reasonable doubt. And second, it's to enable the accused to prepare his defense without being subject to punishment prior to conviction. So in one case, it says that all persons actually detained except those charged with offenses punishable by reclusion perpetua or death when evidence of guilt is strong shall before conviction be bailable by sufficient sureties. One is under custody of the law either when he has been arrested or has surrendered himself to the jurisdiction of the court, as in the case where through counsel, petitioner for bail who was confined in a hospital communicated his submission to the jurisdiction of the courts. So the other rights in relation to bail is the right to bail shall not be impaired even when the privilege of writ of habeas corpus is suspended. And second is that excessive bail shall not be required. So what are the rules governing applications for bail? So this is under Rule 114 of the Rules of Criminal Procedure and Rules of Court. So what are the forms of bail? So first we have corporate surety. It's a bond issued by a surety company accredited by the Supreme Court. Second is a property bond, an undertaking constituted as a lion on the real property given as security for the amount of the bail. Third is cash bond. So this one is paid in cash. Fourth is recognizance. It is a promise to appear. It is an obligation of record and entered into before a court guaranteeing the appearance of the accused for trial. It is the nature of a contract between the surety and the state. So what is the duration of the bail? It remains in force at all stages of the case until promulgation of judgment by the RTC, irrespective of whether the case was originally filed in or appealed to it. And so when is bail available to the accused? So when he is actually detained or under custody. One is under custody of the law either when he has been arrested or has surrendered himself to the jurisdiction of the court, as we said a while ago. So note that bail is only allowed when the accused is in custody pursuant to a criminal case. But jurisprudence has extended it to extradition cases and deportation cases. So, what are the factors in fixing the amount of bail? So, paano ba inaayos kung magkano yung bail? We have certain factors. First is ability to post bail. I'm sorry if my background noise, maingay talaga yung construction eh. Second is the nature of the offense. Third is the penalty imposed by law. Fourth is character and reputation of the accused. Fifth is health of the accused. Sixth is strength of the evidence. Seventh is probability of appearing at trial. Eighth is forfeiture of previous bail bonds. Ninth is whether accused was given fugitive from justice when arrested. And 10th, if the accused is under bond in other cases. So what are the implicit limitations on the right to bail? First is we have the person claiming the right must be in actual detention or custody of the law. In the case of People versus Donato, one was charged with rebellion, so it was a bailable offense. So he agreed to remain in the legal custody during the pendency of the trial of his criminal case. So the court held here that he does not have the right to bail because by his acts, he has waived his right. Second is that the constitutional right is available only in criminal cases, not in example, in deportation and extradition proceedings, as we said. So note that right to bail is not available in the military. Apart from bail, a person may attain provisional liberty through recognizance. Ito nga yung promise na mag-a-appear ka sa court. Okay. So we go to the next one. When is bail available to the accused as a matter of right, as a matter of discretion, and when is it not allowed? So we go through it one by one. So bail as a matter of right, it happens when before conviction by the RTC, the Regional Trial Court, and the accused is not charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment. And it's also a matter of right before or after conviction by the municipal trial court. So in these cases, the judge can never deny bail. He only has discretion as to the amount. Kaya may hearing din on the amount of bail. Kasi nga, yun lang yung magagawa ng judge if it is a matter of right. As we mentioned a while ago, bail nga is our matter of right. But when does it become a matter of discretion? So first is before conviction by the trial court and the accused is charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment. So in this case, it is discretionary on the part of the court in the sense that it is no longer a matter of right, yet dependent on whether or not evidence of guilt is strong. In this way, there is a judicial determination whether or not the accused should be granted bail. So the court will hold a bail hearing and give the prosecution a chance to prove that evidence of guilt is strong. The burden of proof is on the prosecution to show that the evidence meets the required quantum. So the prosecution must be given an opportunity to present within a reasonable time all the evidence that it may want to introduce before the court may resolve the application, since it is equally entitled as the accused for due process. So second is when there is conviction by the RTC, but the judgment is not yet final, and the offense has a penalty of imprisonment of not exceeding 6 years. So ito yung prison mayor. Then third is when the conviction by the RTC, when there is conviction by the RTC, but the judgment is not yet final, and the offense has a penalty of imprisonment exceeding 6 years, but it is not a capital offense or an offense punishable by reclusion perpetua or life imprisonment. And the accused is not a repeat offender, recidivist, quasi-recidivist, habitual delinquent, or ano siya ng reiteration. So we know these terms from our criminal law 1. Or previously escaped from legal confinement, evaded sentence, violated the conditions of his bail without justification, committed the offense while under probation, parole, or conditional pardon, is a flight risk, which are circumstances of the case indicate the probability of flight if released on bail, and there is undue risk that he may commit another crime during the pendency of appeal. So again, we reiterate, the general rule is that bail is available from the moment that the person was arrested. He may be before or after filing of a formal charges in court, apply for bail up to the time of conviction by final judgment. So ito yung after ng appeal. So no charge need to be filed formally before one can file for bail. So as long as one is under arrest. So arraignment of the accused is not essential to the approval of the bail bond. The bail is authorized. It should be granted before arraignment. Otherwise, the accused may be precluded from filing a motion to quash. Also, the court will be assured of the presence of the accused at the arraignment precisely by granting the bail and ordering his presence at any stage of the proceeding. So we go now to when bail is not allowed. So the right to bail shall not be impaired even when the privilege of writ of habeas corpus is suspended. Di ba sinabi natin kanina? And excessive bail shall not be required. These are the rights in connection with bail. So in the book of Bernas, it said that the requirement of excessive bail can amount to a denial of bail. So ito yung mga times na when bail is not allowed. So we discuss them one by one. First is when the accused has already been convicted by final judgment or when the accused has commenced to serve sentence. Except if prior to the conviction, the accused applies for probation where he can continue on the original bail if one has been given. If not, he can apply for bail. If he cannot avail because of his financial incapacity, he may be released on recognizance. Second is when there is conviction by the trial court, but the judgment is not yet final, and the offense is a capital offense or any offense punishable by reclusion perpetua or life imprisonment. This is because the evidence of guilt is strong as there was already a conviction by the trial court. Third is when there is conviction by the trial court, pero hindi pa final yung judgment, and the offense has a penalty of imprisonment exceeding 6 years but is not a capital offense. Oh, I'm sorry. Wait. So anyway, or a punishable by reclusion perpetua or life imprisonment, and any of the following circumstances are present. So kanina, when we were discussing, it's almost the same kasi as, kaya parang nalito ako, it's almost the same kasi as yung by discretion of the court na when there's conviction by the trial court, pero hindi pa final, ganyan, ganyan, ganyan. Pero here, we have to note, when bail is not allowed, any of the following, di ba kanina, kailangan hindi present yung mga sasabihin kong circumstances dun sa discretionary ng court, or else, hindi naman siya magiging discretionary. It will be not allowed. But here, it should be present. So the following circumstances should be present here. So the accused is a repeat offender, recidivist siya, quasi-recidivist, habitual delinquent. So the accused nag-escape siya from confinement before. He committed the offense while under probation, parole, conditional pardon. So accused is a flight risk. Then there is undue risk that he may commit another crime during pendency of the appeal. So, bail is not allowed, tsaka yung bail is under discretion of the court. Parang almost the same lang siya. Although here, it's more of they committed the offenses and they are also part of the circumstance. The circumstances that I mentioned is already applicable to them. So next is, does a person admitted to bail necessarily have the right to leave the Philippines? So the answer is no. A court, as a necessary consequence of the nature of a bail bond, may prevent a person admitted to bail from leaving the country. Syempre, flight risk nga. A bail bond is intended to make a person available at any time he is needed by the court. Discretion is with the court called upon to rule on the question of bail. We must stress, however, that where conditions imposed upon a defendant seeking bail would amount to refusal thereof and render nugatory the constitutional right to bail, we will not hesitate to exercise our supervisory powers to provide the required remedy. So quantum of evidence should be proof evident or presumption great. Presumption great exists when the circumstances testified to are such that the inference of guilt naturally to be drawn therefrom is strong. So clear and convincing to an unbiased judgment and excludes all reasonable probability of any other conclusion. So we go now to where bail is filed. So this is still under rule of court, rule 114. So in section 17, it said that bail is filed, bail in the amount fixed may be filed with the court where the case is pending or in the absence of or unavailability of the judge thereof, with any RTC or regional trial judge, metropolitan trial judge, municipal trial judge, or municipal circuit trial judge in the province, city, or municipality where the crime is committed. If the accused is arrested in a province, city, or municipality other than where the case is pending, bail may also be filed with any regional trial court of said place, or if no judge thereof is available, with any trial judge, municipal trial judge, or municipal circuit trial judge therein. So this ends our discussion in bail. I'm sorry if I mispronounced some words and medyo nalito ako kanina. I still hope this helps your review for criminal law, for constitutional law too. So thank you for listening.